Every year, communities across the nation observe Black August. The commemoration began in the 1970s among incarcerated activists in California as a way to honor the lives of freedom fighters who were killed or imprisoned. Black August is about reflection, learning, and action. And in 2025, that call is more urgent than ever. Right now, there is a growing push to take away due process. The constitutional guarantee in the 14th Amendment that no one can be deprived of life, liberty, or property without fair legal procedures. With the rise of ICE acting as a federal police force and expanding its reach, this is a threat that cuts deep in Black communities, which have long organized against violations of due process as part of the broader fight against police brutality. That amendment was ratified in 1868 during Reconstruction because Black leaders and their allies fought to ensure that formerly enslaved people and their children would be recognized as full citizens. These guarantees, due process, equal protection, and birthright citizenship, strengthen democracy for everyone. Weakening any one of them threatens all of us. Black August calls us to do more than remember. It calls us to organize. This month, the Alliance for Reparations, Reconciliation and Truth and Catalyst California are lifting up the legacy of Black-led resistance, past and present, to show that the fight for equal protection and multiracial democracy is a fight we all share. Through stories, conversations, and action, we stand with those who continue to expand freedom. Follow along this month as we honor Black August, defend our rights, and work toward a future where justice is real for all. Mark your calendar. On August 27th, join us live for a powerful panel discussion on Black August, due process, equal protection, and birthright citizenship, and how these fights are rooted in Black struggles but impact us all. Black August isn't just history. It's a guide for how we win.
Hello, and welcome to the 14th Amendment Under Fire, a Black August conversation. My name is John Dobard, and I am Vice President of Policy and Programs at Catalyst California. Thank you for joining us for this critical discussion. Tonight, we'll explore the promises of the 14th Amendment and the rights won through Black struggles, as well as the threats posed to those rights and promises by the Trump administration and others. The 14th Amendment emerged primarily as a response to threats and injustices that millions of newly emancipated Black people faced in this country following the Civil War. The final Civil War battle occurred in May of 1865. By the fall of that same year, Mississippi became the first Southern state to enact laws that outlined what rights Black people did and did not have. What Black people could and could not do. Soon, several Southern states followed, creating what are commonly referred to as the Black Codes. These laws, which largely echoed laws in the antebellum South, known as the slave codes, reinforced and perpetuated the social, economic, and political subjugation of Black people in the post-war context. The 14th Amendment, which was ratified in July of 1868, attempted to combat this subjugation and the threats posed by previous Supreme Court rulings, such as the Dred Scott decision, by, among other things, clarifying constitutionally that the newly emancipated were citizens by right, that states and the United States must grant them fairness in legal proceedings, and that states and the United States must apply their laws equally to all individuals, including the newly emancipated. We commonly refer to these rights as birthright citizenship, due process, and the equal protection of the laws. Although these rights emerged largely in response to issues faced by newly emancipated Black people, they have benefited many groups and millions of people in this country. They've also been at the center of an ongoing battle to protect them and to ensure that they are real in people's everyday lives. Joining me today to talk about what these battles look like now are Dr. Cheryl Grills, professor of psychological science at Loyola-Marymount University, founder of Imoyashe Community Support Services, a community research nonprofit, and a member of the California Reparations Task Force. Lisa Holder, civil rights attorney and president of the Oakland, California-based Equal Justice Society, also a member of the California Reparations Task Force. Angélica Salas, executive director of the Coalition for Humane Immigrant Rights, CHIRLA, and a state and national leader in the advocacy for immigration reform and immigrant justice. And Kevin Cosney, co-founder and associate director of the California Black Power Network and a longtime organizer in the Black community. Welcome, and let's begin. Due process has been in the news a lot lately, largely due to President Trump's immigration policy. In the context of talking about that policy earlier this year, Trump floated the idea of sending U.S. citizens to foreign prisons, saying multiple times that Attorney General Pam Bondi and the Justice Department are exploring this idea. They claim this would be for the most severe cases, for the most violent criminals. Given the history of the criminalization of Black people in this country and existing disparities in the criminal legal system, it's not too hard to see how such a policy might adversely impact Black folks and their due process rights. Dr. Grills, what is the history of due process and the Black experience in this country, and where are we in terms of securing due process for Black people?
So thank you for that easy question. I'd like to start with a little context. The 14th Amendment was, in fact, the result of local struggles and national debates on the political status of Black folk in this country in the wake of enslavement and the Civil War. The truth of the matter is that we were not on the sidelines, but rather we were instigators of change during that time. For example, leading up to the civil rights debate at the federal level, in the North and the South, we were busy doing organizing. So, for example, you had grassroots movement efforts in Philadelphia, and there was a group called the Pennsylvania Equal Rights League, led by prominent Black Philadelphians, who led the charge and contributed impetus to the 14th Amendment. You also had freedmen who held a convention in Augusta, Georgia, and that was to define what would be Black folks' citizenship rights. That was a Black-led effort. So you then couple those kinds of organized efforts with the reality of major attacks on Black people at the time. For example, there was the massacre in Memphis in May of 1866 that led to 50 Black people dead and 70 to 80 wounded. You had white rioters in that massacre who went specifically after Black women to use rape as a form of terror. A few months later, in July of that year, you had mob violence led by Confederate veterans and the police in places like New Orleans, and that left over 40 Black folk dead. So these kinds of things, coupled with President Johnson vetoing the Civil Rights Bill, pushed Congress into adopting the 14th Amendment. Now, the intent of the 14th Amendment was primarily to achieve racial equity for Black folks, which was hard to do in the context of enslavement and multi-generational racial trauma and terror. And one legal scholar actually argued that there's actually a cyclical pattern to the erosion of due process and other rights that are supposed to be protected by the 14th Amendment. In essence, we gain some rights and then we see a backlash. And that's what I think we're experiencing right now. So that's the context. Now, within that, when we're talking about due process, there are three basic requirements, in terms of procedural forms of due process. People have to be given notice that the government is going to take actions and the reasons that it's going to do that. Secondly, they have to have an opportunity to be heard, right? we have to have the chance to present and make our case, offer our evidence, challenge the government's claim. And then thirdly, there's supposed to be an impartial tribunal. Can we trust that the decision makers will be fair and unbiased? Well, good luck with that in racialized America. And you're right to cite, in terms of the 14th Amendment, the Dred Scott decision, because it was within the context of the Dred Scott decision that it was said by the Chief Justice, black people have no rights that a white person is bound to respect. And so there is the context, the groundswell for due process. So Zora Neale Hurston said, the present was an egg, no way, laid by the past that had the future inside its shell. In other words, denial of due process from the enslavement and Jim Crow past laid the foundation for what we see today and the mindset that feeds the erosion of due process and the risks and threats. Baldwin also said people are trapped in history and history is trapped in them. In other words, the mindset and the cruel, inhumane, and unjust efforts across American history to the present day actually reflects a deterioration of the American psyche when it comes to fairness and justice and due process. And so why do we need it? One, half of the nation's pre-Civil War presidents enslaved African Americans while in office. Two, more than 1,700 congressmen from 37 states once enslaved African Americans. Third, by 1861, nearly 2% of the US budget was allocated to pay the expenses of African Americans. And then you have, as I wrap up on this, there are multiple examples in every sector of American life where our due process rights are challenged or at risk or being threatened. But there's another side to it, and I have to, as a psychologist, invoke that part. And that is the psychological terror and the psychological warfare that is meted against us. And I'll give you a really quick example that I think most of our audience will understand. I'm talking about the talk. Every black parent knows about the talk, and we're not talking about the sex talk. We're talking about the talk with our children about racialized America and what we need to do and what they need to do to stay alive and to protect themselves. Well, within the context of that talk, you have the reality that parents aren't able to have the sense of security that they can fully protect their children. And I just have to say that there's a statement here about that says that black parents are essentially trying to parent powerlessly, in essentially a powerless stance. That is psychological terror that we have to also contend with. We cannot underestimate the impact on our mental health and our well-being as we fight the fight and we express our resilience and we do our part to make sure that we have the treatment of full human beings and citizens in this society.
Mm-hmm. Thank you, Dr. Grills. I'd now like to turn to equal protection of the laws. In 2023, conservative legal organizations scored a victory in their continued war on efforts to improve educational opportunities for traditionally marginalized groups, particularly black and brown students. In Students for Fair Admissions v. Harvard, the Supreme Court ruled that consideration of race in college admissions violates the Equal Protection Clause. Now those organizations have set their sights not on race, but on what they deem proxies for race that educational institutions may use to create opportunities for students in differing circumstances. For example, one organization is suing Boston for its use of zip codes in allocating seats to its prestigious exam schools. Another organization has filed a Title VI complaint against Johns Hopkins University for its use of family income as a way of determining free tuition for medical school. Although these attacks focus on education, and that's bad in itself, there's concern that the implications of their previous and potentially future legal successes will go beyond that issue, and that the current composition of the Supreme Court will continue to interpret the Equal Protection Clause in ways that undermine equity efforts, whether we're talking about race, class, geography, or what have you. Lisa, does the currently dominant Supreme Court interpretation of the 14th Amendment suggest that the Equal Protection Clause will be an impediment to equity efforts for the foreseeable future?
Another easy throw. Okay.
Yeah.
So, Dr. Dobard, I'm going to talk a little bit about the Reconstruction Amendments, the 14th Amendment. But I always say the Reconstruction Amendments because we're not just dealing with the 14th Amendment, we're dealing with the 13th, 14th, and 15th Amendments. And I just want to start off by saying and commending you for framing this around the 14th Amendment specifically and using that constitutional principle and starting to normalize it in conversations, taking it out of the courtroom and bringing it to the people and doing public education around the 14th Amendment. When you use this legal construct as a jumping off point for understanding democracy, equity, inclusion, and social justice, it's just very important for cultural literacy to do that. So I commend you for using that framework. But I also want to caution us about how we use the 14th Amendment and understand that it is a legal term of art. Many of us, myself included, have gone to law school. We've been in litigating cases for 20, 25 years and studying constitutional law. And so it is a term of art on the legal side that comes with a very specific set of standards and that is steeped in legal jurisprudence and decades worth of cases and case law. So that said, let me talk to you about the legal side of the 14th Amendment. And then I'm going to talk to you about the political side, which goes to the current makeup of the court. But right now, let me talk purely about the legal side. One thing that we need to understand is that all and any race-conscious programming is permissible as long as it meets a very high standard called strict scrutiny, okay? The media always gets this wrong. Everyone gets this wrong. They say, oh, race-conscious program is illegal. No, all race-conscious program is legal under the 14th Amendment as long as it meets strict scrutiny. That's called constitutional law. This is a primer, a 2-minute primer on constitutional law. So strict scrutiny means that basically the government has a compelling interest in doing race-conscious policy, and the policy itself is narrowly tailored to meet that interest. Nothing is off the table when it comes to race-conscious programs. And then, really, what people need to understand is that in order to meet strict scrutiny, there's a set of laws under a standard that was articulated in the Croson case that basically says if you can establish that there are decades of disparities in outcomes or patterns of disparities in outcomes, and you can use a very sort of scientific methodology where you're bringing in anecdotal qualitative evidence based on what people say and what people are experiencing, as well as quantitative evidence of experts that show that discrimination is a dynamic from the past. It's also a dynamic that's continuing in the present, and it will continue into the future. Once you can bring in all that scientific social science and establish that the government still has a compelling interest based on that history and that reoccurrence of discrimination, then all you have to do then is show that the policy is narrowly tailored, and boom, you have strict scrutiny. You can do race-conscious programming. Now let's talk about the political side, which has to do with the makeup of the court. Now let's understand that today's court is not yesterday's court. So, when we decided to finally have a democracy in this country between 1960 1954 and 1965 with Brown v. Board of Education and the Civil Rights Act, we finally said we're going to have a multiracial inclusive democracy. Anything that's not multiracial inclusive is not democracy. What we had before then was not democracy. So when we committed as a nation and as a court to have a democratic nation and interpretation of the Constitution, we basically made it clear that the 14th Amendment can be used, again, in a race-conscious way. And in fact, the Chief Justice of the Court in the 70s, Harry Blackmun, said the only way to end racism is to first take race into account. There is no other way to do this. And so that was the political, moral, and ideological orientation of the Supreme Court throughout the 20th century, right? There was a recognition that the 14th Amendment was supposed to be interpreted and implemented in a race-conscious way. That has now shifted. We have a 6-3 situation, but let me just talk about the 3, which is led by Justice Ketanji Brown Jackson. Again, she has articulated very clearly that when the 14th Amendment was adopted, it was adopted in a race-conscious way, and race-conscious programming is still viable, and it is still constitutional. Now we have the other 6 in the majority. And they obviously create an impediment to doing equity programming. However, we've talked specifically about the SFFA case and equity in the education context. The bottom line is that people need to understand that this court has basically said diversity is not a compelling interest. Okay, fine. There's a whole bunch of other compelling interests that can meet strict scrutiny, right? And so there's doing things for the purpose of remediation, so remediating past harms. There's doing things for the purpose of intervention, so you can intervene to abate future discrimination, compelling interest. And there's also doing things for the purpose consistent with the mandate of the 13th Amendment, which says that Congress must pass laws that abate continuing forms of slavery, right? So Congress has a mandate to pass laws that abate racial profiling and the vestiges of slavery. And those are all compelling interests, right? So just do your homework. What I have to say, the action item, I'm a lawyer, but I'm really an organizer. I always have been. So the action item for lawyers and for activists, et cetera, is do your homework. Put together those disparity studies, those harm reports, meet the Croson standard, and let's show them that we can meet strict scrutiny and we can do any kind of race-conscious programming that we want to do and that needs to be done, as long as we can show that there are still these outsized burdens for Black people.
Okay, that's giving me some hope. Thank you, Lisa. So now I want to go on to birthright citizenship. This, of course, has been very controversial in the news over the last several months and was sparked by Trump signing an executive order in January that clearly targets immigrants. Angélica, how are immigrant communities and advocates dealing with this effort to constrain who can be an American?
Well, I think that the first thing that I also want to really commend you for talking about the 14th Amendment, because my perspective, and based on all the work that we're doing, is that the attacks both legally and physically of immigrants in this country is an attempt to hollow out the 14th Amendment and all the protections that actually are enshrined both in the spirit and in the letter of the law. And so it begins with birthright citizenship, this idea that a person who is born in the United States is of the United States, is a citizen of this country, which was affirmed in 1898 with United States versus Wong Kim Ark, which was the United States was challenging his citizenship based on the citizenship or the lack thereof of his parent. What ended up happening is it was affirmed. He was a citizen of the United States, and that has been what has affirmed that citizenship. And so what the Trump administration has done is what many others have tried and attempted to do in the past, which is to say that a child born of an undocumented person who does not have citizenship in this country, therefore, is not a citizen. And we continue to fight that and say absolutely a person born in this country is a citizen. But it goes beyond just birthright citizenship. It's also challenging the naturalized citizen. I'm a naturalized citizen of the country. I was not born in the United States. I actually came to this country as an undocumented individual, as a child. I then became a green card holder and eventually became a citizen of the United States. This administration is also challenging the idea that individuals who hold naturalized citizenship can retain it, and actually it could be denied to them arbitrarily. So the notion of citizenship, of the easy denial of citizenship by birth or by naturalization is extremely problematic. But then it goes on to the attacks around due process rights of individuals being having the protection of the Constitution. So what this administration is also saying is actually, if you are an immigrant of this country, whether undocumented or otherwise, you're not protected by this Constitution, certainly not by the 14th Amendment. And then you can see this in the manner in which people are currently being detained and arrested without charging documents. Being detained without being told why they're being detained, detaining the non-citizen as well as the citizen, having the individual then detained without access to counsel, and in many instances being taken to detention centers in the United States and outside of the United States where neither counsel or family members could actually find those individuals, going straight to the law. And then the other issue that we're also finding is, in terms of the 14th Amendment, is this idea of racial profiling. So what it's also saying is that certain individuals can be detained, can be literally grabbed from the street simply because of who they are and what they look like. So right now, in the case of Pedro Vázquez Perdomo, against Nome, what we are challenging is this idea that a person can be detained in the streets simply because they look a certain way, so they're Latino, or people of color, and I'm going to say because it's people of color in general, and then that you speak a certain language or speak English with an accent, the kind of job that you're doing, whether it's you're in a certain industry, you're a day laborer, you're a street vendor, you're a car wash worker, or you just happen to be near those industries. And then the other piece is also the location, where you live or where you're walking or where you're waiting for the bus. So we're challenging these ideas that simply being a non-citizen allows the United States and it allows the Department of Homeland Security to literally yank you from the street simply because these are conditions or these are criteria by which these officers are picking up. My perspective is what they are trying to do is use the immigrant community as a test population to say how far can we go in order to make sure that the 14th Amendment doesn't really have the power that it has always had, that sought to actually bring a whole population in, formerly enslaved African Americans into belonging in this country. And my perspective is what is happening right now with immigrant communities is seeking to hollow it out and make it as meaningless as possible, not just for the non-citizen, but for all citizens, beginning with Black Americans.
Thank you for that. Another guy, I appreciate you uplifting that this is an attempt to hollow out the 14th Amendment, and that folks might think this is just about immigrants, but we should see this as a test case that will likely go beyond immigrants. Are there other threats that citizens should be taking seriously, particularly Black citizens, when it comes to these attacks on birthright citizenship? So anything else to add, or from anyone?
I'm just going to add the whole idea of habeas corpus, to know where are you being detained.
Yeah.
So we talked a little bit about individuals being sent to other countries. We have situations where people are being sent to detention centers within the United States, and we just can't find our folks. We don't know where they're at. And so individuals who have been detained in California have been moved to Texas, Louisiana, New York, Florida. They're being moved to Washington State, but many, as you know, have been moved outside of the country and are being detained in other places. And we don't know where are they traveling, where are they going. So we've had to actually really use the whole notion of habeas corpus and seek to compel the government to basically notify us where people are. And the one thing that I also think is really important is this whole idea of also bail or bond. That in many instances we then have individuals who do have access to counsel who are not being allowed to have access to bond in order to fight their case outside of detention.
Thank you.
Yeah, and if I can jump in, my organization, the Equal Justice Society, we have been doing, along with LDF and the League of Women Voters, the amicus briefing on the birthright citizenship cases. And 4 of those are going through the courts right now. We had a huge victory in the Ninth Circuit last month, where now the Trump administration and Trump's executive order to try and eliminate birthright citizenship, they're the ones who are under fire. And the Ninth Circuit said, no, birthright citizenship is enshrined in the Constitution. You can't have some random executive order and overturn the Constitution. So that was a huge win. But with respect to birthright citizenship, we need to understand the long game here. What's happening with this repression army on the right is they are going after birthright citizenship, and today it's manifesting with the terror of immigrant communities and the ouster of many immigrants. But the real prize is voting, and ensuring that people are disenfranchised, limit the franchise, and ensure that people of color do not have access to the polls. And one way to do that is by creating all of these, putting all these parameters now around birthright citizenship and around citizenship generally. And the way that is going to be implemented later on is through making it more difficult to access the polls, right? So just like, the literacy laws that where African Americans were not, if they were not able to prove literacy and all, had to jump through all these random hoops that no one else had to jump through, that sort of limited the franchise and disenfranchised so many African Americans. The same thing's going to be happening with birthright citizenship, using that as a way to limit people's access to the polls. Oh, well, you have to prove that, that for generations you have been here, that things like that. And so it is going to have a hugely disparate impact, as all of those types of limitations on voting always have on Black communities.
Yeah. So, did you want to get on?
Yeah, absolutely. I really appreciate the framing of really the central point being the dismantling of rights, right? Because this is an authoritarian regime. And that begins with dismantling rights, and they start with the most vulnerable communities and continue to see how far they can push it. And that's really what's at stake here. So when he says homegrowns are next, we know what that means. And there's been plenty of folks say, oh, well, they can't deport me, I'm a citizen. Listen, brother, sister, family, if they can import you, they can deport you.
Right.
And that's how we got here. So that can certainly happen. And I think when we talk about democracy and various other rights, we're seeing these attacks now in Texas with folks eviscerating Black and brown political power. So this is the goal, is to dismantle the rule of law, dismantle our rights so they can reign, right, freely. And I think the other concerning factor here that I want to add into this conversation is the way in which they're going about it with the expansion, militarization, and coordination between local and federal law enforcement. And that should be of deep concern to all of us, and especially black folks who are at much further risk, right, for police and state violence. And so I think that's a critical piece to understand, that this is also this dismantling of rights is happening through force, right? And that's critical.
Thank you all for those insights. Finally, I do want to shift us again to the struggle for reparations. The 14th Amendment was one attempt to deal with the aftermath of what has often been called America's original sin, the system of chattel slavery. 160 years since emancipation, we're still dealing with it. Kevin, can you speak to what those efforts look like now, particularly the growing movement for reparations in California and across the country?
Absolutely, and I want to ground this in some common understanding, right? Because I think from the onset, there's often a simplification of reparations as cutting a check or 40 acres and a mule for stolen labor. And that's certainly a critical piece and something that's probably most tangible for folks. But I think it's important for us to understand slavery as not just a system of exploitation of labor. First and foremost, it's a race-based system, right, that is inherited to your offsprings and to others, right, just based on race. It was also, right, a system that was dependent on bodily control and violence, not only physically but mentally, spiritually, etc. And I think most importantly to this conversation was a system that was founded on second-class citizenship, second-class humanity, dare I say, the denial of rights and access to democracy, housing, education, healthcare, etc. And I think what's even more critical is that this is an unbroken chain. There have been attempts to adjust these things, but we know that the 13th Amendment wrote slavery into the Constitution. And we saw the exploitation of labor carried on through convict leasing systems to our current prison system. And even now, as black folks, pretty much no matter what city we live in, even if it's a predominantly black city, struggle to find jobs. We see that now, again, in this mantling of voting rights and power, right, in these attacks on democracy. We know what it means to, again, be denied the right to a jury and a trial, right? Oftentimes, jury and execution is happening in the street. And we know that these things come in ebbs and flows, spikes and valleys, as was alluded to earlier, and this is certainly a moment of spike. And I say all that to say that there's the dynamic nature of slavery is important for us to pinpoint, because the repair needs to be equally as dynamic. And I think it's important to frame and understand and start this conversation with UN principles that says, yes, compensation is a core tenet of reparations, but so is restitution, being able to restore that which was taken or broken, rehabilitation, satisfaction, and, right, the guarantee of non-repetition and cessation of harm, right, which means you can't keep hurting us if you're saying that you're going to repair us, right? That's the basics of an apology for those of you who have kids, right? We know that you can't keep doing the thing if you're saying you're sorry for the thing. And I think that's what's critical at this moment, because this current regime is building off of the harms of the past, building off of those narratives, continuing to reopen them. And we have to address those if we're ever going to move forward as a country. We have to have honest, real conversations and honest and real repair. And, right, if we're going to thwart this autocracy, this fascism, we have to give something bigger and better for us to believe in. So what does it mean to really move from a regime of harm to a government of repair and care? And so I think that's foundational to this conversation of reparations, and allows us to have a more expansive, not only expansive conversation, but expansive repair that really gets at all of the issues that we're talking about here and now. And so I think it's important to note, obviously here in California, we have two of the task force members that were leading the efforts in the California study of the harms that Black Californians have experienced, and then put forth not only a robust study, but hundreds of recommendations on how you repair that harm, because again, the harms are in the hundreds, the repair needs to be in the hundreds as well. And this has sparked waves of conversations in other states, from Illinois to New York, Maryland, and cities like San Francisco and LA County, where reparations is continuing to gain momentum in conversations at a political level, but also at home, at the dinner table. And I think that's critical as we continue to mount pressure, not only to make the recommendations that the California task force put together a reality, but also continue to push for things like HR 40 at the federal level, because that's ultimately where some of this conversation needs to land. Since then, we, as California Black Power Network, have linked arms with some of the task force members and grassroots organizations around the state, like Catalyst California, Black Equity Collective, Live Free USA, just to name a few, to launch what is called ART, the Alliance for Reparations, Reconciliation, and Truth. And that is a multiracial effort to support reparations for Black Californians, based off the recommendations of the task force, to bring those into fruition and make sure that we can move an agenda that takes on those recommendations one by one and sees that Black Californians are fully repaired and made whole and equal in this society, in the state. That's taking on a number of issues this year around first setting up a bureau to make sure that we can actually manage reparations and oversee that process, to things like restitution for eminent domain, taking of properties, to homeowner grants, right? To, again, make up for the years of redlining and predatory loans that we've seen, right? And again, this is important to frame that these harms aren't just things that happened in the 1800s, but are happening in my lifetime and in our lifetime here and now. And that is what this effort is about, restoring those pieces, and again, making sure we're not seeing the erosion of rights. And so I think our call is to have Californians, all Californians, join us in this fight, because we know that when Black folks do better, everyone does better. And particularly in this moment, particularly as we're talking about Black August, it's important that we take a stand, right, for our rights, for repair, and really to make sure that we're pushing for freedom, right, in the face of fascism.
Thank you, Kevin. This has truly been an enlightening conversation. I've certainly appreciated the insights on the historical context, ways to understand the threats that are being posed, as Angélica said, the hollowing out of the 14th Amendment, as well as the hope that we should have and suggestions on how we fight against those attempts to hollow out. There's a lot more that we could certainly say and talk about. For now, I want to thank you, Dr. Grills, Lisa, Angélica, Kevin, for participating in this important conversation. And I'd also like to thank everyone who joined us online today. We'll be posting this conversation on Arts and Catalyst California's YouTube channels. Please stay tuned for more. Connect with Art and Catalyst California on social media, and subscribe on our websites to learn about what you can do or what more you can do. And we'll see you again soon.